CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS
Talk to
Talks.
me.
Real information.
Talk to me.
Real education.
Talk to me. Talk to me. They don't talk to me. They look like that morning. They don't talk to me. That morning. They don't talk to me. That morning. They don't talk to me. That morning.
And we're back into part 2 of the issue with Lionel, Coveney and eFlow. And just to explain for listeners that are not of the island, we're dealing with eFlow, which is a company that represent the national toll roads, which run the toll roads around the island. And they take money from people for travelling on said toll roads. Okay, so we were at a stage and we identified clearly that there was a Judge, John O'Neill, involved in this, and he basically sidestepped the law, he ignored the law, and said that he would not be using that law in the court today. That would be ignored, basically. And you then had the prosecution came forward, they got their order from the court in terms of issuing a fine based upon an alleged offence for travelling through a toll road without paying. And they got the order, and you then, Lionel, were looking for a copy of that said order, which they obviously have to have perfected and which they have to then take up, and they cannot pursue you otherwise unless they have this legal order from the court. So as it transpires, did you get the order?
I never got the order. The order wasn't forthcoming, and furthermore, when I inquired as to where the order was, I inquired both to the solicitor and the courts. The court said there was no record of it.
Okay.
And I asked them, would you have access to it, even though it's held by the solicitor? And they said, of course, we would. There's no perfected order. And I then contacted the solicitor in writing, and I asked a number of questions, and I said, look, I need a copy of that order. Mm-hmm. Why are you not giving me the order? What's going on here? Is this a perversion of justice? And I asked all kinds of questions. I don't have them to hand, but...
So essentially, now, as far as I'm aware myself from the research I've done, and possibly some of yours as well, they have what's called a reasonable time frame in which to perfect the order. Okay. So given that, when, not precisely, but when roughly did this alleged case take place? What year, month, roughly?
About 2 years ago. It was December. I know it was a December, early December of 2013.
Okay,
yeah,
so
December 2013.
We're at least a year and a half, coming on 2 years, and to date, no order has been perfected to your knowledge, and certainly you have not received a copy of said perfected order.
No. And the only correspondence that I received from the solicitor since then, he seemed to disappear, and these guys, as anyone will know, are quite aggressive in when they're pursuing. The following January, and this was when the next case, I mentioned in the last episode that there was another case pending for a few more alleged toll road fines or violations or whatever they call them. In January, they had tried to hear both cases on the same day.
Okay.
And I said I wasn't prepared because they had been scheduled, and basically the solicitor and barrister tried to put the two together, and I said no, I wasn't having any of that, and I was happy for it to proceed
individually. Yeah.
And I inquired then in January as to when exactly the case was being heard, and I was told it wasn't, and it was being postponed, and I'd be informed as to when it was. Anyway, next correspondence I received was late January to say that there had been an order or a ruling against me for they had the wrong case number, they had the wrong amount of money. It seemed to be something completely different.
Technical.
Yeah. So I wrote back again. I said, look, what is this? What's going on? Has there been a case heard without informing me, etc., etc.? And I mean, this was a long legal tome notice demand sent out, and that was the last I have ever heard. So that sort of
dissipated then?
That just seemed to go away since then. So I mean, the last letter I wrote was quite sobering.
Yes.
And it didn't really leave room for yes or no answers or any kind of response.
Now, just in retrospect, again, I'm trying to go through my mind as to remembering what you were informing us of at the time. Did you write to the court in relation to the alleged order? Did you physically sit down, pen and paper, and write a letter to the court looking to seek for a copy of the order?
I did, yeah, and I included the judge on it, and I
Again, Judge John O'Neill.
Judge John O'Neill, and I wrote to everyone I could think of. I wrote to Ken Murphy in the Law Society and all the usual people that I CC on my letters, because I think the more people you can make aware of this, the better, particularly if they're moving in these circles and want justice to be seen to be done.
So again, obviously we can't fully close the chapter, but why do you suspect then that this is dissipated, for lack of a better word, in respect of what had gone on in the court? Why would you suspect that they didn't perfect the order, they didn't bring it forward, and they didn't enforce the order?
Well, from the perspective of the court and the solicitor, and I tried to look at it, and I did look at it from their perspective afterwards. I said, okay, well, this guy has come into court and he has stood on something that we know is the law. We've told him that it doesn't apply. That didn't work, because he then came back at us with, well, I'm going to judicial review potentially, and I'm going to appeal, which would be, of course, then in the circuit court, in a higher court with a different judge. And we don't want this to rear its head, because the bottom line is, if I'm relying for my income on ignoring that all grants and promises of fines and forfeitures of particular persons before conviction are illegal and void, and if ignorance of that is necessary to my profession, I'm going to do everything I can to brush under the rug that sentence if it comes to light. And I had brought it to light on the record in court. Well, if I'm that solicitor, I don't want that going any further. I'm happy to let that one fine go away
disappear,
so that I can continue to collect the hundreds and thousands every other day.
That all right, we're kind of second guessing what was in their heads. Obviously we don't know if that's the way they were thinking about the whole process. But then would you suspect that if, say, that they had stood and agreed with you that was the law, okay, and you had won the case, what was the outflow of that? What would happen then beyond that? Well, if you won on the basis of the Bill of Rights and the section we quoted?
Well, potentially every single fine in the country is null and void or illegal. So for starters, they've no way of generating income. When I say they, I mean the state. How are they going to generate income in the future? And anybody who has been fined in the past can potentially come back at the state and sue them.
Notwithstanding that people still could.
They still could.
Irrespective.
Because the law does state what we have said it states. It does.
And again, for you, the listener, you should, it's not that you should do anything, but we'd suggest that it might be in your interest to educate yourselves about the Bill of Rights and the specific sections we're talking about. Again, this section of the Bill of Rights is set just below the issue of parliamentary privilege. So it's a good guideline if they're still enforcing this, and we've heard about it in the news in more recent events.
It's quite topical, yeah.
Exactly, and there was people being prosecuted and not being prosecuted for parliamentary privilege, but the law still stands. They still have parliamentary privilege, as does the Bill of Rights in relation to fines and fees and forfeitures and convictions and them being illegal and void if you're not being convicted, if you haven't been convicted. So again, all we can say to you folks is go and research this. We've stated what the information is. All it requires is a simple put in the information into Google. It'll come up straight away.
That's it. And don't be put off by the fact that the Bill of Rights Act is from 1688. As you've stated, Des, it still applies.
Okay, very good. So there it stands at the moment, and notwithstanding that the court, Rhubarb and co could come back still and try and enforce if they get the order. But obviously you'll have to have a copy of that order if it exists at all.
Exactly. And I was denied my right to appeal because I needed that order so I could see exactly what I was appealing.
Correct. Absolutely. So that's potentially a miscarriage of justice,
as I saw it, and I clearly stated that in my notice demands and my letters to everybody involved in the case.
Okay, grand. Now, so that's one potential defence you could have had in relation to the more recent stuff, in relation to the guard alleging that you were on the phone, alleging that you didn't have tax. Now, obviously you didn't bring this in because you won the case on another defence, if so to speak. So that's pretty comprehensively covered, and obviously laterally we can do more stuff on the Bill of Rights if necessary. But what was your potential next defence you could have had in relation to the guard attempting to prosecute you for being on a phone while driving and for an alleged no tax display?
The next one was quite interesting. It's one that I have observed over the last number of years from just going into court and looking and seeing what's going on, that's a tool that I've used to try and familiarise myself with the procedure, and so that I'm less intimidated if I ever have to go in there myself someday. And as we all know, I have had to go in now. So I'm glad that I have gone into court quite a bit in the past just to see what's going on. And I've noticed that a lot of solicitors will use the defence of the Gardaí or whoever it is prosecuting being unable to prove beyond all reasonable doubt.
Be able to prove beyond all reasonable doubt. Okay.
Now, I've also noticed that they're pathetically bad at defending their clients. Almost every case that I see, when I critically analyse it on the spot, when I'm in court, and I have no legal training per se, formal legal training, it's so blatantly obvious that these cases are all winnable. The defence cases are all winnable. The cases are defendable. Yet these solicitors who are legally trained, while they seem to know initially what route to go down, they're unwilling to in any way aggressively pursue that route. So they'll go a certain way down the path and then stop, and that's it. If they haven't got what they want at that stage, which they rarely seem to have, well, then they seem to be willing to lose the cases, and it doesn't seem to affect them or bother them in any way.
It sounds like you're suggesting that they may be putting on a pretense, putting on a show initially, only to know in the background that their clients are not going to be defended correctly, but to put on the show.
That's absolutely what it looks like.
Yeah.
And it seems to be they're happy to proceed with the charade because it gets the cases through the court quicker and quicker. The quicker the cases are, the more clients the solicitor can take on and, in inverted commas, defend in court. And that all equates to more money and more fees.
Of course. So, go back to the point you were making then. Could you reiterate it again for us, just so the listeners can...
Unable to prove beyond all reasonable doubt. So, as we've established in previous episodes of the podcast, I'm being charged with a criminal offence. And under the law in Ireland, if you're charged with a criminal offence, you are presumed innocent until proven guilty.
Yeah.
So, I'm presumed innocent walking into that courtroom.
And the court will tell you that if you ask.
The court will tell you that. So, can I shed any kind of doubt on the prosecution's case? So, I mean, reasonable doubt is the term. Prove beyond all reasonable doubt. If there's any kind of reasonable doubt, now reasonable can seem a wishy-washy term, but we can attack it on a number of different fronts. So my aim with this defence, or this potential defence as it turned out to be, was to show that the prosecution were unable to prove beyond reasonable doubt that I did what they were alleging I did.
Okay, grand.
I.e. non-display of tax and speaking on a mobile phone while driving. I did my research and I looked into a couple of different cases with regard to presumption of innocence. One that is very worth looking up is Woolmington versus the DPP from 1935. And again, don't be put off by the antiquity of certain cases and how old they may be, because if they're in law, they're in law. And if they apply, they apply. It doesn't matter what year they were in.
So you're looking at precedents that were set in the court.
Exactly, that could potentially aid me, that I could refer to in court and say, well, Judge, according to this case, this is what the law states. And it's essentially giving examples to further bolster your argument. Another case was the DPP versus DOT from 2003. Now, Justice Hardiman in that case, and this is something I honed in on, stated that the presumption of innocence is a vital, constitutionally guaranteed right of a person accused in a criminal trial, and that the right has been expressly recognised in all of the major international human rights instruments currently in force. And to further that, Article 6.2 of the European Convention on Human Rights, which we would fall under, states that everyone charged with a criminal offence shall be presumed innocent until proven guilty according to law. So we're not just dealing with the laws of Ireland, we're dealing with a human rights issue here potentially as well. So
from my recall, I think that's also quoted in the Gary Doyle order on the DPP guidelines for prosecution as well. They do relate back to the European Convention on Human Rights.
So this is something that they have to abide by. So if this can be brought up in court, as I had planned on bringing it up in court, well, woe betide potentially any court that ignores that.
Absolutely, yeah. Well, again, as you suggested, Lionel, it gives you grounds going forward. Again, hypothetically speaking, if you had lost the case on whatever merit they deemed, that you had a point of law then to move forward on again.
Exactly. And again, I'm assuming that I'm going to have to appeal at some point. I'm preparing for the worst. I'm hoping for the best, preparing for the worst.
Yeah.
So thinking of it as, well, where will my appeal be strong?
Correct.
And hopefully then it won't come to that.
Well, again, I think you said it earlier anyway in the earlier interviews that psychologically you had prepared yourself that if necessary for any of these cases, if it had to go to Europe, the European Courts of Human Rights, that's where it would be.
Well, that is a tool available to us, so why wouldn't we use it if we're trying to defend our rights?
It's only the price of a Ryanair flight, isn't it?
That's it.
Or whatever you use nowadays. Not to plug them either, to be honest.
So, Des, there was another term then, burden of proof, that I looked at.
Okay.
And one of the consequences of the presumption of innocence, which we've already discussed, is the placing of the burden of proof on the prosecution.
The accuser.
Exactly.
Yeah.
So it's the responsibility of the accuser to establish the guilt of the accused, i.e. me.
Makes sense.
As a result, if the accused raises a defence, then it's the responsibility of the prosecution to disprove that defence, not the responsibility of the accused to prove his innocence. So, I'm sitting there and I don't have to prove my innocence, which, I mean, most people would automatically think, yeah, well, you have to prove you're innocent. Well, by law you don't. You simply have to shed doubt or cast doubt on the prosecution's case.
Folks, you can probably see the links here. This harks back again to the Bill of Rights Act. Innocence. You know, you are innocent and nobody can fine you unless you've been convicted.
So they have to prove that you're guilty.
Correct.
And if you receive a fine, that's not proof that you're guilty. And furthermore, if you're in court, not only are you not assumed to be guilty, you're assumed to be the opposite, to be innocent. So you start,
not guilty. Yeah.
You have a standing point of innocence.
Yeah.
And
or as they put it, not guilty.
Not guilty.
Not guilty, yeah.
Exactly.
Look, can I ask you something now? Just probably a bit of a sidestep as well, but it's not. It is relevant. You did mention earlier in one of the interviews, probably the later interviews, about pleading, making a pleading.
Yeah.
And so what is your view on when you go into court, as you know the process and some of the listeners may be familiar with it, when you go into court, the judge very often will say, how do you plead?
Yeah.
In either of the cases, did you make a pleading? I think you did mention this earlier, but...
Yeah, in the initial hearing I didn't, when I was looking for the case to be struck out, based on the fact that the original guard wasn't there.
So why didn't you make a pleading?
Well, as I saw it, I thought, well, if I plead, the case begins. And if I'm saying to the court that this case shouldn't begin because there's no evidence here and it should be struck out, well, wouldn't it be foolish of me to allow the case to begin?
Absolutely. I concur with that.
So,
yes.
If I'm standing on a point outside of the nitty-gritty of the case, if you like, if the point of law is almost outside of the case, well then I should be able to defend from outside the case without allowing it to commence.
Again, well, I'd add to that as well. How could you logically put forward a pleading, be it guilty or not guilty, if you haven't seen what evidence they have against you?
That's a very good point. It's impossible.
That's the whole point, isn't it? I mean, and very often we've heard of this, and I know you're cognizant of this yourself, Lionel, where we've talked to people and the judges have pushed people on making a pleading. Irrespective of the fact they've sought the evidence, they've sought a Gary Doyle order, judges will push, and they have pushed people into making pleadings. And
sometimes they'll even put words in the mouth of the defendant and they say, okay, so you're pleading not guilty or you're pleading guilty. And quite often somebody who had gone into court quite obviously with the intent of taking a particular standpoint, they're kind of harassed into agreeing with the judge at some point because so many people are fearful and they don't want to annoy the court because they think that they'll be more lenient if they're not annoyed or whatever it might be. And the judges do, and I've seen it time and time again, they do cajole the defendant,
at the very least, that's the nice way to put it.
A polite way of putting it, into pleading one way or another.
Yeah.
Because they want that case to begin. So the sooner it begins, the sooner it's over.
I mean, and as you have noticed and noted yourself, is that as soon as the case begins, it's pretty much over and done with if you get into that area of making a plead.
Yeah.
I can't see how anybody can do it. But again, if you have been, as Lionel has suggested, cajoled or harassed into making a pleading, again, that is another point of law. They cannot put pressure on you. They cannot rush the judgment.
Yeah.
And if you initially said, look, I cannot make a pleading because I haven't got the evidence, how can I plead against something where I haven't been presented with evidence, and the judge has pushed you? That's a rush to judgment. And they've put pressure on you. So they've cajoled you, they've coerced you, and they've done it. They've created undue pressure.
Exactly.
Which again, that's a criminal offence as it happens. Anyway, let's get back to your issue of burden of proof. I think we were talking about. Yeah.
So I decided, right, if I'm going to shed doubt on their case, I'm going to have to ask a few questions of the guard. So once the guard has given his evidence, I'll need to cross-examine him, as I did in the case when it was won. Yeah. So the questions were going to be slightly different this time round, because bearing in mind there was very little evidence. We had got our Gary Doyle order. We knew what we were up against in terms of what that guard could rely upon
evidence. Yeah.
So I thought, right, well, I'll ask some questions related to what he hasn't got, which are still pertinent.
That's interesting.
Yeah, so let's look at one of them. I'm accused of being on the phone while driving.
Okay.
Now, in his evidence, he had no proof whatsoever that I was on a phone of any description. How could he? I hadn't been. So a simple question: what phone was I holding?
Well, if he's alleging you were on the phone, he should know
Yeah,
that basic stuff.
exactly. Another question: where is the phone?
Yeah, he should have that as evidence as well. If he's relying upon stating that you were on the phone, he should have taken that as evidence, if nothing else.
Another one: where is the evidence to prove that I was holding it?
Yeah, well, there's obviously ways of getting records of times and dates and conversations and all the rest of it, so he should have had that evidence as well.
And furthermore, I had that evidence myself, and at that point I would have been willing to address the judge and to state that he cannot prove that the call was made, received, or texts or phone, because I had the phone records.
the records.
And I was able to show that there were no texts, there were no calls received or made, and whatever else it might be. So I mean, that was, at that point, it was potentially somewhere that I could have looked to have the case dismissed.
Yeah.
Let's imagine, though, that the judge wasn't going to accept that. So I had some more questions for the guard, such as: what reasonable grounds have you for believing that a fixed charge offence was committed?
Okay.
So let's have him
yeah.
state the grounds.
Okay.
Because if he can't do that, well, again, that weakens his case substantially.
He has no grounds.
He
exactly.
has nothing.
Yeah.
Isn't it true that you hold the burden of proof to successfully convict me of these alleged offences?
I think you should state that again. Isn't it true?
Isn't it true, guard, that you hold the burden of proof to successfully convict me of these alleged offences?
That's a fair statement to make. I hope everybody's listening.
Yeah, and he has to agree.
Yeah.
Because we can quote the law to him. If he disagrees, he's in a spot of bother. If he agrees,
Yeah.
well then, let's show that he can't prove.
Well, if he disagrees, then he immediately becomes a very unreliable witness, because he's admitting he doesn't know the law. Isn't that it?
Well, there you go. And he has to know the law.
Absolutely. Well, if he's trying to prosecute you under whatever laws, and we seen earlier and we read earlier, but there was 2 sections he was under the Road Traffic Act.
Yeah.
He needs to know those laws, but not just those laws. If he's going to prosecute you under those laws, he needs to know all the law.
Yeah.
And specifically where it comes to burden of proof, he needs to be able to prove beyond any reasonable doubt of his allegations against you.
And it's also worth noting again, our frame of reference here is the fact that I already hold the evidence that he's relying upon. Anything outside of the evidence he had provided me with is inadmissible, so he can't suddenly bring other stuff in. So I know what he has and he doesn't have, and more to the point, what he doesn't have, because he has very little.
Well, if he did, on the flip side of that, if he did have evidence, then, and he didn't bring it, he didn't show it, he didn't demonstrate he had it, he didn't give you a copy of it, then he could potentially be guilty of criminally withholding, stifling, suppressing evidence from the court, which in itself, as the word suggests, it's a criminal offence to do that.
It is, and it doesn't matter that it would be harming his case per se.
Yeah.
That's not the issue. The issue is he still has done it.
Correct.
Potentially.
Yes.
So, another question then. Isn't it true, guard, that you have no evidence allowing you to prove beyond all reasonable doubt that I am guilty of these alleged offences? Now, we know from the documentation that we have that he doesn't have any evidence. So no matter what way he answers that question, we can demonstrate that there's no evidence. So we either catch him in a lie, or we then seek to have the case dismissed again.
Well, if you catch him in the lie, that's one thing. Okay, then you can go on. There's another tangent you can go off on.
Yeah.
But if you catch him and he tells the truth, then he still has no case.
Exactly.
So either way, I won't say the word, but he's knackered. Right?
He is, and his case is built on a lie anyway. So
Yeah. But again, not forgetting, folks, that the guards are there, and we're not knocking the Garda Síochána. Don't get us wrong with this. We're just knocking the ignorance of the Garda Síochána. They should not be ignorant of the law. And secondly, the DPP, they prosecuted the suit of the DPP. In other words, the DPP allow them, and they say, yeah, go ahead, that's one we can prosecute, so on and so forth. So it's not just the Garda, it's the DPP stroke the state that are prosecuting you. But the DPP facilitate all this going on behalf of the state. So it's not just the Garda Síochána that are at fault here. There's a whole schema of personas behind this that are persecuting and prosecuting people for these alleged criminal offences, which in this case specifically there was no criminality involved in it. So just keep that in mind, that it's not just the guard that's there at the front line, it's the DPP backing them up and it's the state backing the DPP up. There's a whole plethora of personas behind it that you're up against.
Exactly. And furthermore, for those who might still take a cynical view and think, well, why would all these bodies and people collude to try and harm people? It's quite simple. Everybody's being paid every step of the way.
Correct.
So there's your motive straight off the bat.
Yeah, it's commerce, it's money.
Yeah. So, I mean, that kind of closes that defence. I had prepared a closing argument, if you like, which I'll read out there. It's not that long.
Yeah.
So when addressing the court, I would, to reference what we've already discussed, with the burden of proof patently on the prosecution and in cognizance of Wilmington versus DPP 1935 and DPP versus DOT 2003, wherein Justice Hardiman did state that, and we stated above basically that presumption of innocence is vital, allied with Article 6.2 of the European Convention of Human Rights, which states that, again what we've already discussed, same point, and in the absence of said proofs, we must be presumed to be innocent of these charges and consequently now move to dismiss with prejudice.
Dismiss with prejudice.
Yeah.
Very good. Okay.
So that was another potential defence that I thought was pretty strong, and was perfectly happy to use that in court if the need arose.
But again, notwithstanding you won the case on the first point you made anyway, then you had a second defence, and then you now have a third defence. Even at that point, if you'd have lost the case, you still would have had not just points of law, but precedents that back up the point of law that you're basing your defence upon. So again, you would have room there to go forward for a judicial review and appeal at the click of a finger. It wouldn't have been a difficult thing.
You're ready for appeal.
Yeah.
And I think one of the traps I was eager not to fall into when I was approaching any of this legal work from day one was not to get to a certain point and then realise with hindsight, well, yeah, I lost that case because I wasn't fully prepared. And a great piece of advice that the Common Law Society gave to me was prepare to lose. And I've said it loads of times on these podcasts. Prepare to lose. Prepare your appeal. Have that ready, because you don't want to have to scramble and do that within a week if you've lost your case that you thought you were going to win. So assume that you're going to lose, and you might get a better outcome than you had prepared for, and that's great. That's a great outcome then. Yeah,
that's a fairly good direction to get from anyone. But equally as well, Lionel, is that if you start bringing in this stuff that you've brought in, and if you had the need to bring it in, you didn't at this point, luckily enough, you're also informing the court that you are prepared to go all the way, which is what the court do not want to hear, that you are prepared, because nothing would have happened to you other than, right, the next stage is a judicial review, an appeal, blah, blah, blah.
Yeah.
So you're actually bringing up the knowledge to the court and saying, well, look, be cognizant of this. This is not going to just sit here if I lose this case. I'm not going to lose this case. Although technically, as far as they're concerned, you would have lost the case.
Yeah.
You're saying to the court, right, you say I've lost the case, I say this is a long way to go, and the court do not want to deal with that. They don't want to have that on their books. Potentially something like this could destroy something like the Road Traffic Act, completely decimated. And it's a point, before we click off, it's a point we were discussing earlier.
Yeah.
In relation to, if we could just close out on this issue, or this point, in relation to definitions of certain words, specifically mechanically propelled vehicles, which we discussed at length before the interview.
It kind of further highlights how every single word is potentially a tool that you can use once you study what words mean. So there's a very clear reason that vehicle or vehicle is used in certain cases as opposed to car or jeep or lorry
or transport or whatever.
Exactly, because they are different words, and if they're different words, they have different meanings, and there is quite often an assumption, and I would be guilty of this a lot in the past, certainly not so much now, but still guilty of assuming that two words, because they are similar, are the same. And we're quite often led to believe that words are the same when in fact they're similar but not the same. So if there is a distinction, and again, look at law dictionaries, look up Black's Law online, whatever it is, whatever your source is, look up the meanings of, for example, transport, transportation, vehicle, and see, is there a distinction? Because you'll suddenly go down another rabbit hole, in a sense. So if you start looking at what a vehicle is and the definition, you'll come across another word, passenger. Now, for all intents and purposes, a passenger is somebody who sits beside you in the vehicle. Or is it? Because in law, it's actually something different, and there's something that was uncovered by several people in their research when dealing with different cases. And that's that a passenger, when you look at the law, there has to be some kind of a financial remuneration or a transaction take place. So is that the same as somebody just hopping into your car?
As a companion.
Yeah, and it does say that a vehicle, a mechanically propelled vehicle, for the purposes of transporting passengers. I mean, that's what we're dealing with when we look at the Road Traffic Act. So if a passenger isn't a passenger, unless it's to do with money, unless you're a taxi driver, well, is that passenger really a passenger in law? Because if it isn't, you've just opened up a serious can of worms there.
And this goes back again, folks, to the definition of a mechanically propelled vehicle. And again, you can look this up in the Road Traffic Act. Some of these terms are defined, and then obviously you may have to go to the dictionary because they don't drill down into every single word, unfortunately. And a passenger, as Lionel has suggested, is aligned with somebody that is paying a fee.
Exactly.
So that defines what a mechanically propelled vehicle is as part of the definition of a mechanically propelled vehicle.
And while it is pedantics, the pedantics are important.
Absolutely.
Because the law is built on pedantics. And it is clearly written by pedants. So whilst we're often told in daily life, oh, don't be pedantic, really do when it comes to trying to protect yourself in the law, because when you look at the etymology of words and the words themselves and what they actually mean as opposed to what we assume they mean, you can find some very, very key and vital and useful information in there.
Well, just to close out on it, I'd like the listeners to imagine that if they were ever in a position whereby they had to appear in a court in relation to minor criminal charges under the Road Traffic Act specifically, it wouldn't do them any harm to research what a mechanically propelled vehicle is defined as legally, and then secondly, as Lionel has suggested, what the word passenger means, because it is there in black and white.
Yeah.
And then perhaps put forward at some stage a cross-examination in relation to whoever is attempting to prosecute you or who the accuser is. And I'd suggest that if you went down the route of that sort of questioning, that the case would probably disappear pretty rapidly.
I would think so, because this is not information that is in any way conducive to the smooth running of the court system.
Absolutely, yeah. I mean, imagine if the court did agree with you that the word passenger was defined as somebody that was paying a fee. Then it would be up to the Garda or whomever to prove that you had a fee paying passenger in the car, which defines that you were driving a mechanically propelled vehicle. And that would be a virtual impossibility to do so, unless you specifically are, as Lionel suggested, a taxi driver.
Yeah.
Or you carry people on a bus for commerce. So it's an area I think that has to be looked at, and certainly there may be listeners out there at the moment that are looking at these types of things. I would suggest it's well worth your while looking at that, and not to give it too much of a promotion, but I know you did yourself, Lionel, to look at the book called The Gary Doyle Order, because it gets into some of that as well in terms of preparation for some of your potential defences.
Well, I don't mind stating this again. Without the book The Gary Doyle Order, I wouldn't have gone down this path, and I'd still be in a position whereby I'd be paying fines for things that I didn't do in this case, just to get rid of them because I'm afraid. And it is the Gary Doyle Order that set me on this path with regard to criminal matters. I was already examining the law for civil matters, but with regard to criminal, which I thought would never affect me in any way, But then again, I didn't realise at the time that road traffic offences are criminal.
They're all criminal,
They're
correct.
criminal offences.
Yeah. Now, just to, we'll close it out there, and thanks very much, Lionel, again. I know we're reversing the roles here somewhat. I'd like to ask the listeners to suggest areas of the law that they would like to see covered. Obviously, we'll continue anyway, and we'll find our own process for covering certain aspects. But if there's any specific areas of the law that you yourselves would like to hear covered, that we have covered, that we know of, we'll try our best, obviously, to do it. So, if you don't mind me just saying this, Lionel, I'll just put in the contact details.
Yeah, absolutely.
So, if people could send an email to info@thecommonlawsociety.com, or get in touch with us through thecommonlawsociety.com, and we'll certainly do our best to try and give coverage of the aspects of the law that they want covered.
Yeah, and it's also worth noting at this point that we're now on iTunes. Some of you already probably listening on iTunes, but it's not just YouTube anymore. We're on iTunes, so you can subscribe and have your fix of the CLS talks automatically downloaded to your phone or your computer, whatever it is. We're on Stitcher as well, and we're on all the other various devices, so you don't have to just be on Apple. So you can find us all over the place now.
Well, finally, Lionel, thank you very much for coming into your own studio again today.
Sure, it's always a pleasure. Thanks, Tez.
And thanks very much, folks, for tuning in and listening.
We'll talk again very soon.
The CLS talks.